Yes, sir.
Okay, we are allowed for sharing the PPT. Okay, thank you. Yeah, yeah. Thank you, Anjali ji.
There are 19 registrations, but people have not joined. I can't understand why.
All right, all right. So I once again offer my thanks to the ICSI IIP and Anjali ji for my brief introductions over here. So the today's topic which has been assigned to me, just a second, please. Yes. So the today's topic which assigned to me is practical intricacies in the liquidation process. So as you all are the IPs, I assume, and we are here to discuss about the liquidation process. So before start the session, let us have an overview. What are the regulations? What are these IBC code sections which actually deals with the liquidation process? So we have prepared a brief of the sections and the regulations which actually covers. So just for the sake of just for setting the stage of these discussions and the practical difficulties or the intricacies we all are facing in the liquidation process, we will discuss it later. So let us have the uh, overall sections. So in respect of liquidations, basically three there is chapter 3 which comprises of only 22 sections in all from 33 to 54 of the IBC code. So as you know that section 33 which is there which deals with the initiation of the liquidation process. So section 33 we will discuss during the course of our discussions. Section 34 is there which deals with the appointment of the liquidator and the fee of the liquidator. Then we have section 35 which deals with the power of the liquidators, duties of the liquidators and the responsibility which is cast on the liquidator. Then section 36 is there dealing with the liquidation state. So liquidation state is stated very relevant, very important, because if anything is not there in the liquidation state, liquidator cannot liquidate that. Then we have section 37. 37 deals with powers of liquidator to access the informations. Section 38 is there which prescribe how the claims will be consolidated. Then section 39 is there which deals with the verification of the claim. Again, section 40 which prescribe the admission and rejection of the claims by the liquidator. Section 41 determination of the values and valuation of the claims. 42 appeal against the decision of the liquidator. Section 43 to section 50 which we also have studied in the CIP process deals with the preferential transactions, its relevant time. 44 in that regard the order in case of preferential transactions, avoidance, undervalued transactions, and these all are covered under section 43 to 50. Then we have 51 order of AA in respect of extortionate credit transactions. 52 is there regarding the secured creditors in liquidation proceedings. Distribution of assets, then under section 53, which is the waterfall mechanism. Then finally, section 54, where it deals with the dissolution of the corporate debtor. So this is the chapter 3 under the IBC where we study or we have to deal with under the liquidation process. Apart from that sections, the liquidations process regulations are there. So under the regulations, there are 47 regulations all in all. And these 47 regulations are divided into 7 chapters and 1 schedule. So we should have a look on the scheme of the liquidation process regulations. Chapter 1, which deals with the preliminary part, definitions and all is there. Then chapter 2 is there, appointment and remuneration of the liquidator, which deals with section 34 under the main code. Then chapter 3 is there, powers and functions of the liquidator, covering section regulation 5 to regulation 11. Then we have chapter 4, that is journal. Chapter 5 is there regarding the claim, deals with majority of the regulations covering from 16 to 31A, where stakeholder consultation committee is there. Then we have chapter 6, realization of the assets, regulation 32 to 40. And finally, regulation 41 to 47, chapter 7 is there, which prescribe how the proceeds of the liquidation shall be distributed. One schedule is also there, which prescribe the mode of the sale. And one voluntary liquidation we probably may not cover in this. So if we look this entire scheme under the IBC and the regulations, so there are 22 sections which deals with covering from section 33 to 54 and regulations, 47 total regulations under the IBBI liquidation process regulations 2016. Now let us visit the presentation part which we have prepared. So today, as the topic is intricacies under the liquidation process. So what is the objective of this session? To my mind, to decode the liquidation process under the IBC. This is the objective we will discuss. We all are learner because we see the amendments and things which are coming, and the amendments are very frequent. Even we have the IBC Amendment Bill 2025 in hand, which maybe soon be the law, which deals with certain amendments under the liquidation process also. We will have the objective of identifying the key practical challenges at each stage of the liquidation. We will discuss this, analyze the strategy decision making required of a liquidator, and discuss the real world case scenario and stakeholder management. So this is the brief objective. Considering this, we have prepared certain slides to discuss before the learned participants. So this entire discussions or presentation is divided into 5 parts, and at last we will take the question answer. We can discuss and frame the question, make the answers to understand, to clarify our doubts or practical challenges which we are facing in our liquidation process as a liquidator. First part we have covered is the foundations and initiations. Second part, taking control. Third part, we will discuss liquidators, tightrope walk, and powers and stakeholders. Then core mandate, assets claim, final act, sale distribution, all. So these all are the stages where we have divided our the entire discussions into the part. So to start with, something which comes into our mind, what is the liquidation? So as a layman or as a general understanding, liquidation is the liquidating the assets of any person, then distribute the proceeds to set up the liability as per the prescribed procedures. So we can simply say liquidation is the selling in a simple or common man terms, that liquidation is the selling and the sale proceeds is distributed. Why does it happen? Section 33 prescribes the stages or the reason when the liquidation will be initiated. Then what are the further procedures? This procedures is prescribed from section 33 to section 54 and regulations prescribed by the IBBI. So this entire things has been the process which is the inevitable in the liquidation. The fundamental mindset shift, we all know that under the corporate insolvency resolution process, there is a rescue culture, means we focus, or adjudicating authority or the government lawmaker all focus on the revival of the CD, corporate debtor, under the corporate insolvency resolution process through restructuring mode. But under the liquidation where the revival is not possible, the liquidation starts. So the culture is realization culture in the under the liquidation, and the focus will be to sell, to liquidate the assets, get the maximum value from the liquidation of the assets which are part of the liquidation state, and this is the critical distinction between the CRP and liquidation process, because the focus is shift. So liquidation process, we have this if you see the diagram which is there, asset realization, debt settlement, distribution. So this is all the part under the liquidation. So for the sake of understanding, liquidation is the process of last resort for value maximization. In number of cases where CRP could not succeed, there was no resolution plan, the adjudicating authority order for the liquidation, or the COC can order for the liquidation, resolve for the liquidation, and accordingly the RP has to file the application before the adjudicating authority for order of the liquidation. So what are the key triggers for liquidation which prescribes? Section 33 is there, which lays down the broad guidelines or the provisions, and that is the trigger point of the liquidation. In a bullet point, we can see that failure to receive a resolution plan during the corporate insolvency resolution process. During the CRP process, RP, COC, and all the stakeholders which are there, they try their best to resolve the insolvency of the corporate debtor through the resolution process. But in cases where the resolution process is not succeed, it lead to the failure of the resolution plan, or the resolution plan may not at all there, then this liquidation is inevitable. This is the trigger point of the liquidation process. Second scenario can be rejection of a plan by the adjudicating authority. So we can see the cases where the COC approved the resolution plan, and after the approval of the plan, RP has to submit the plan before the honorable adjudicating authority for its decision on the resolution plan. And in cases where the adjudicating authority finds something which is not as per law, or the AA think that this plan should not be approved, then the plan is rejected by the honorable AA. In that scenario, the liquidation is triggered. Then we have the COC decision to liquidate during the CRP with 66% voting share. Section 33 prescribes Section 33 prescribes one of the conditions also, that if COC decides for the or resolve for the liquidation of the corporate debtor with 66% vote share, then the corporate debtor may go into the liquidation. Another point is contravention of the approved resolution plan by the debtor. This is the post plan approval scenario. Suppose a resolution plan is approved by the adjudicating authority, and in the terms of the resolution plan are contravened or may not, the plan is not implemented. In that scenario, the resolution plan contravenes and the corporate debtors stand into the liquidation. There is a case where the Bhushan Steel, which is well known to everyone, that under the Bhushan Steel, the approved resolution plan was not was challenged before the Honorable Supreme Court. Supreme Court order for the liquidation of the CD, but again that order was also reviewed by the Supreme Court, and I think the order is reserved in that matter. Let us see what will be the outcome. So these are the points where the liquidation process actually start in any of the four trigger point which happens in any of the process. So accordingly, we can say the liquidation is not the starting point, it is the outcome when resolution fail or there is no resolution. We will cover these primary triggers in details, although we have briefly discussed this, how and when the starting point of the liquidation triggers. So no resolution plan received within the statutory timeline 30 days. As we all know, yes. So as we all know that under the IBC code, no resolution plan received within the statutory timeline, maximum 330 days. We already covered this. This is the maximum timeline which is prescribed under section 12, which says that the total CRP timeline is 180 days and with maximum 90 days extension, it is 270 days, but the maximum time limit is there 330 days. In 330 days, if the resolution plan is not received, the CD has to be liquidated. The A has no choice but to order liquidation. We have discussed this under section 33 in the previous slide. Trigger 2 we have dealt with in detail before that the committee of creditors can vote to liquidate anytime during the CRP. Here we can discuss one thing. Recently, in one of the cases where the COC in very first meeting, considering that there is no asset in the company, during the very first COC meeting, when the within 30 days RP has to convene the first meeting, then in the very first meeting COC was willing to resolve for liquidation, and the RP requested the COC that, see, this is very first meeting, let us complete the CIP process to go further, otherwise there may be challenges before the Honorable NCLT. NCLT may ask why you are resolving in the very first meeting for the liquidation without attempting to resolve the corporate debtor. But the scenario or the response or the wisdom of the COC was that, see, there is no asset in the company. There is no point in taking up this process, CRP process forward, because resolution will not be there because there is no asset. So what will be done? So anyhow, in that meeting, this liquidation was not passed. Resolution for the liquidation was not passed. It was deferred to the next meeting. And in that meeting, the COC also not confirmed the appointment of the IRP at RP also, because COC was thinking that what will be the benefit of running this process. So in the second meeting, let me tell you that in the second meeting, COC resolve for the liquidation of the CD. Accordingly, as per the COC decision, RP, though he was not confirmed as, though the IRP was not confirmed as the RP, he was acting by default as per the CRP regulations as RP. He has to file the application before the NCLT. And you will be surprised to know that Honorable NCLT, while hearing the liquidation application, raised so many questions on the RP that you have not exercised the complete, you have not performed the duties as per the prescribed under the IBC and regulations. So in that case, what RP can do? There was no asset, nothing was there. COC resolved for the liquidation, but NCLT can do anything. I open this stage for the experience or for the exposure. If any of the learned friends may have come through like this scenario before the NCLT hearing. Is there anyone can please share the experience in that regard? This is one of the case where I felt I faced this difficulty. If anybody want to share, then it's good for the sake of understanding all the participants. No. All right. So the practical intricacies which I was discussing here, that no viable business, rapid asset deterioration, believe that liquidation would yield a better return than any potential plan. There may be cases where COC wants or COC assume that getting the CD into liquidation as early as possible based on the nature of the assets or viability of the business. So in that scenario, the COC can very well resolve for the liquidation even before completion of the timeline. But the condition is that on 66% voting share is required to trigger this COC decisions. Another trigger we can discuss in detail regarding the contravention of an approved resolution plan. A successful resolution applicant failed to implement the approved resolution plan. There are scenarios or there may be cases where the terms of the resolution plan based on which the plan was approved, the terms is not being fulfilled by the SRA, then the trigger will be the liquidation of the corporate debtor on failing of the implementation of the resolution plan. This upholds the sanctity of the resolution process because the plan, if cannot be implemented, it is better to get the CD into liquidation. The AA in that scenario has no choice but to order liquidation. But practically, if we see that liquidation is the last resort, there are cases where the adjudicating authority wish to restart the CRP process rather than sending the CD into the liquidation, because if the CD is resolved, then the business and the economic viability of the I'm sorry for disturbance. Just a minute. Yes. So these are the trigger point where the liquidation is triggered on failure of the implementation of the resolution plan. Then we come to the legal framework. So the legal framework under the IBC or the liquidation process is that the law IBC, specifically chapter 3 and 5, which I have in the beginning go through the presentation, that these are the sections and these are the regulations. Then finally, the adjudicating authority, which is the final authority for any of the applications or any of the process to decide whether it's right or it's is within the four corner of the law. So this is the legal framework. So as a liquidator, once the liquidation process is initiated, the first and foremost responsibility of the liquidator is to take control of whatever assets of the CD are there. Although in almost all the cases, the liquidation process starts after the resolution process is fails. The RP is having the control of the assets of the CD. There are cases where the RP change and the person who is assuming the duties of the liquidator, or the person or the IP who is to be appointed as the liquidator, is different from the RP. In that case, the liquidator has to take control of the entire assets or the CD of the uh, assets of the CD or the CD as a whole. So here we have this first 30 days. So this is the very initial period. This is the foundation of the liquidation process. Initial actions of the liquidator, the entire process, speed and thoroughness are paramount for the liquidator. And once the liquidation commence, that is the liquidation commencement date. This is the very important date. We have to remember this date during the entire process, because the timelines which are prescribed under the IBC and the liquidation process for the liquidation process is based on the LCD, liquidation commencement date. So that is the cutoff date. The first 30 days are there. So we will see the timeline at a glance here. So these are the timelines we have prepared in a bullet point. Liquidation commencement date. After the liquidation commencement, when the order of the NCLT release or uploaded on its website, or the person who is appointed a liquidator get the certified copy. It depends on, because some IP prefer to get the certified copy. Only after that they start the liquidation process. But some RP, when they get the order uploaded on the NCLT website, they take it as the cutoff date for them. The public announcement of the liquidation process has to be within a period of 5 days from the appointment of the liquidator. So once the liquidator gets the order, from that date, he assumes that it is the LCD for him, and he publishes the liquidation commencement announcement asking for the submission of the claim from the various stakeholders. So this is the very first step of the liquidation, and the time limit is 5 days. Then within 7 days of the liquidation commencement date, the liquidator has to appoint the registered valuer. Earlier,
Sir, excuse me, sir, can we appoint the same valuers appointed by RP in liquidation stage, or we have to change the valuers?
so there is no such restriction. The valuer has to be IBC registered. So
Okay,
it
that is
he
clear.
can yes, he can be the same. There is no restriction. But if you are appointing the valuer during the liquidation period, it is always better to have the other liquidator, other valuers which are other different from the CIP process. or you may adopt the same, take the same, no issue.
So there is one more question regarding valuation. There is option to take the valuation done at the time of resolution process without doing valuation again at liquidation stage. There are
Yes,
certain provisions, no?
yes. There is no mandate that you have to appoint a new valuer, correct? So many of us used to take but see the cases where we have the very old valuations, correct? So in
Okay.
that case, it is always advisable to appoint a new valuer because of the assets values deteriorated.
Yes. There may vice versa also. It may
Yes,
have.
sir. Yes, very correct. Then submission of the creator's claim, liquidated within 30 days. So this is the another timeline which is very important because this 30 days timeline has to it is mandatory because liquidator has no option to get the claim accepted after this 30 days period. So every stakeholder has to submit their claim within 30 days of the LCD. After this period, liquidator, I would request to please mute yourself if it is not required because there is some disturbance. Thank you. Then verification of the claim. So liquidator has to verify the claim which are received within a period of 30 days into the next 30 days. So from the liquidation commencement date, it is the 60th day up to which liquidator has to verify the entire claims which he has received during the liquidation period after public announcement. Then a liquidator has to constitute the stakeholder consultation committee within 60 days of the LCD. So this provision is specific there. Filing of the list of stakeholder with the adjudicating authority within 75 days of the LCD. So this 75 days means almost 2.5 months. So after liquidation commencement, within 2.5 months, liquidator has to file the stakeholders list. Then preliminary report, same timeline is there within 75 days of the LCD. Preliminary report has to be filed by the liquidator. Then, sir, distribution of the proceeds of the stakeholder must occur within 90 days from the receipt of the fund. So after preliminary reports, and the liquidator started this process of liquidation. Liquidation proceeds comes in between the liquidation account, which is also required to be opened by the liquidator. Then within 90 days of the receipt of the fund, the provision is that distribution has to occur. The liquidator may apply for the disclaimer of the owner's property within 6 months from the LCD. Suppose the assets are not, it's like the NP assets. For the sake of understanding, you can have. And overall liquidation period prescribed is 1 year from the LCD and extendable by 90 days by the A. But this timeline never, I mean, in cases there are number of years the cases are running, it is not possible to complete the process in this very strict timeline. So adjudicating authority tend to grant us extension or exclusion, whatever it is there. Then in under the liquidation process, we have to file progress report each of the quarter. We have to comply with the IBBI regulations also regarding filing of the liquidation forms. So these are the strict timelines which we have to adhere, we have to understand, we have to comply as a liquidator during the liquidation process. So for the sake of understanding or for the brush up of our mind, we have jot down here for a glance. Now, this first 30 days after the claim is received, next is see, this is the NCLT order. what is the starting gun for any liquidation? The date of NCLT order, which I have just explained, that when the order is actually uploaded, or the some of the liquidator prefer for getting the certified copy, this liquidation commencement date is there, the date of order. Upon commencement of the liquidation, we can see the moratorium which was in force during the CRP, which is lifted. This moratorium is over, but under section 33 subsection 5, a new and stricter moratorium applies, which says that no legal proceedings by or against liquidator, by or against corporate debtor, except with the adjudicating authority approval, can be initiated. So liquidator is liquidation is or you can say have the rights to initiate the proceeding with the approval of the adjudicating authority during the liquidation process. So section 14 goes and 33 subsection 5 comes in. So this is the starting of the NCLT order. Public announcement, we have during the time during the presentation of our timeline, we have seen that it is within 5 days. It has to be published in 2 newspapers, one in English, another is in the vernacular language, and it is also to be submitted to the IBBA website. And this public announcement calls for the claims of by the stakeholders to be submitted within 30 days. And the forms prescribed is Form B for the public announcement. So this is brief about the public announcement. Every IP has to publish this, so we will not go into everybody is knowing this. Then we are here action 2, critical communications. So if you see that during the CRP also, once the CRP order is released or it is pronounced, then we as RP used to communicate with the various government agencies, statutory authorities, bankers and all, that CRP has been initiated. In the same line, during the liquidation, after liquidation commencement date, public announcement we have made in Form B, we also has to send the communication to each and every person who are some or other how associated or affected with the corporate debtor. So we have to think who are those persons. We publish the public announcement, that is fine. We send the individual communications to all the bankers, to all the financial creditors which we find in the books of accounts of the CD, to all the sectorial regulators like Securities Board, Exchange Board of India, RBI, IRDA in case of it is a insurance company, RERA in case of real estate company, development authorities, even to the societies, if it is a real estate company where the projects are running, then we send this communication of commencement of the liquidation to all the persons so that sufficient information reached out and they can submit the claim before 30 days. Because after 30 days, the liquidator cannot accept the claim. Then practical intricacies, failure to do so can lead to the continued legal actions. So here we can.
Sir, one query. In liquidation, we have to send communication to all creditors. We have to send to creditors also, no? So, in absence of complete details of creditors, because suspended board is not cooperating and 19 application is still pending with NCLT. So it is practically very difficult to send communication to all creditors in absence of complete contact details of the creditors.
Correct. You are right. So see, That is why there is a provision of public announcement, correct? The public announcement is the announcement where it is assumed that it leads to the all the persons who are affected or who are required to have the information. But in case we have the informations, okay, then it is always advisable to send these separate communications to everyone.
Right.
So I'm not saying since you are not having the details, how can you send the info, the communication? It is not possible. You are right. But if it is there, then you should have. That is the intention.
Right. Thank you.
So failure to do so. So we can see the cases where there are number of operational creditors. And as Bhupenderji rightly pointed out that we do not have the communications, we do not have the address, suspended director has not submitted the documents, how can we know? So it is always better to publicize this as much as possible so that the stakeholders can submit their claim. That is, otherwise, if 30 days is gone, it is lapsed, then it is the adjudicating authority who can condone the delay, liquidator cannot, and that is on the application by the person or by the stakeholder who could not file the claim within the time. And it will lead to the delay in dissolution of the company, of the corporate debtor. So it is advisable that everybody must submit the claim within the time. Liquidator must resort all means to communicate whatever it is to the maximum possible extent. Then coming to the action number 3, after this public announcement and all, and sending communications to everyone, visit all premises. First and foremost task or responsibility of the liquidator. But though the liquidator and its team should visit all the premises of the corporate debtor, get the notice board affixed there, or circulate the information about the liquidation process commenced, change locks and security protocols to his satisfaction. If required, then agency may be hired if there is big premises, or otherwise the security may be changed or may be continued, the existing security, but control has to be taken, and that is the physical control of the assets of the CD has to be ensured by the liquidator. Then create a detailed inventory of all plant machinery and stocks. Have the Panchanama. Take control and custody in a very, very documented form. So this is the first and foremost task which the liquidator has to ensure. There are cases where many difficulties or many problems being faced by the liquidator. Even the police case and all has also happened during this exercise. So this has to be done, but with a very, very precautions also, because safety is also important for the liquidator and its team. Do the things which are important also, as well as to save ourselves. If there is any apprehension of miscreant, then it is always advisable to inform the concerned police station that on so and so date you are visiting to take the custody. Inform the police station, take proper security and safety measures, then go to take the physical possession of the assets. So this is the very important task for the liquidator. After this, the physical assets, there may be the digital or intangible assets also in any CD. Often it is these kind of assets may be overlooked, but they are equally important. Liquidator has to take control of the servers, email systems, website, ERP data, any intellectual property rights, company website, social media accounts, whatever informations are required which are in the form of digital data or intangible assets, liquidator has to prepare the list considering the working or the nature of business of the corporate debtor and what may be the assets which are in the form of digital assets, what may be the data which are required. So on the basis of that common understanding, liquidator has to take control of all these things also. For this purpose, liquidator can take the assistance of the digital experts. In many cases, I have seen when we as a liquidator or even as a RP visit the premises, we rarely find any data. We do not find the computer system, or if it is they are there, there may not be proper instrument. They are in a very bad condition. They cannot be restored. So in all these cases, we have to document it, everything, the present status, present state of the documents or the data. We all have to mm, jot it down, take the proper signature from the persons who are the persons of the CD or the security person, just to prove that you have exercised all your due performance of duties. That's it. Then we can divide this into the financial takeover. So we have the physical takeover, we have the digital takeover, then we can see that this is the financial takeover. So write to all the known banks. As in the very first step, you may have sent the communication to the bankers of the CD. In the meantime, if you will discover that there are other bankers or financial institutions, you can send the communication about the liquidation process. Take control of all existing bank accounts. Open the new bank account in the name of the corporate debtor dash in liquidation. This is the mandatory conditions. Within period of 30 days, liquidator has to open this bank account in any of the bank, scheduled bank. And remember, all the transactions, all the financial transactions must route through this newly opened bank account. So this is the financial takeover. Then managing human capital. So the liquidation orders act as a deemed notice of discharge of all the employees. So once the liquidation is ordered, it is deemed that all the persons of the corporate debtor are discharged. So this is the importance of the liquidation order and liquidation commencement date. You have to identify and rehire, if required, the KMP for the smooth handover and assistance in the process. Who can assist you during the liquidation process? You have to take the assistant of those people. But once LCD is started, it is deemed discharge of all the personnel of the CD. After this entire process, the preliminary report concept is there. This report has to be filed within 75 days of the liquidation commencement date. This report contains the capital structure of the corporate debtor, estimate of the assets and liabilities of the corporate debtor, and the plan of action which the liquidator has to take during the liquidation process, timeline, all has to be there in the preliminary report. The report is the, you can say, the first and formal blueprint for the liquidation process. So this report has to be filed within 75 days of the liquidation commencement date. Then what is the importance of taking the custody or taking the early action? If we delay in taking the physical possession of the assets, there are chances of theft. So the action must be swift, must be very quick by the liquidator in taking the custody of the assets as soon as possible after the liquidation commencement order. So the cost of delay is enormous. Part 3, duties and powers of the liquidators and the powers of the stakeholders consultation committee. We will be discussing this. We can take 5 minutes break here. In 5 minutes, we will start again. Please. Is it fine, sir? Up to 5 minutes. Anjali ji, are you there? We will be starting in 5 minutes. All right. So part third, powers, duties and stakeholders. So under this part, we will discuss the liquidator's tightrope walk. As a liquidator, we has to balance, we has the immense power to balance the things. Stricter duties and the expectation of the shareholders are there. We have to we have to be very careful, or we have to very balanced in this process. So as a liquidator, the first duty is verification of the claims. Take the custody and control of the asset, then liquidate the assets. In case the CD is a going concern as on the LCD, then to carry on the business to certain time, then to realize the liquidate the asset, then distribution of the sale proceed. These all are the key powers of the liquidator which are prescribed under section 35 of the code. So if we see the verification of the claim, we can see here that this is the process. Start with submitting of the claim by the various stakeholders as a consequences of the publication of the Form B. Then the liquidator has to consolidate all the claims, verify the claims accordingly submitted by various stakeholders in this process. And this entire exercise covers how creditors, employees, and other stakeholders must submit their claim within the deadline which is there in the Form B, public announcement. So forms are prescribed for each of the stakeholders. Liquidator has to verify whether the claim form is correct. The role of the liquidator in verification of the claim is, after verifying the claim, liquidator has to take the decision with reason whether the claim is acceptable or not. He can admit the claim or he can reject the claim. If he is going to reject the claim, it is with the reason, and the list of the claim he has to upload at the IBBI portal also, and the list of stakeholders has to be submitted with the adjudicating authority also. After verification of the claim, so there are number of steps in verification of the claim. The claim verification from the records of the CD. There are practical challenges we all face in our liquidation process because insufficient records pose a challenge to the liquidator how to verify these claims. So based on the records submitted by these particular stakeholders, he has to verify whether the claim can be accepted or not. Then the liquidator prepare and file the category-wise list of the stakeholders, like who are the financial creditors, who are the operational creditors, who are the employees, what are the government dues. So all these category-wise list has to be prepared by the liquidator, and the list of stakeholder has to be filed. Another important role, or we can say the duty of the liquidator, is to constitute the stakeholders consultation committee And this is the committee which actually exercised the first advisory, or you can say the control over the liquidators or supervisory over the liquidator in the liquidation process. Earlier, before 16th September 2022, the role of stakeholder consultation committee was purely advisory in nature. But after the amendment, stakeholder consultation committee has been given the power even to replace the liquidator with another. Liquid stakeholder consultation committee has been given enormous power under the code akin to the committee of creditors, and the rights of stakeholders to inspect the list and challenge the decision of the liquidator also there. So whatever actions or whatever task liquidator has to follow, it is to be very fair and transparent manner. There must not be anything which is conflicting. So these things has to consider by the liquidator. Then the documents provides the detailed explanation of liquidation state, which is there under section 36. So this is the another duty. So we will discuss this. Firstly, let us again come to the main slide. Power deep dive to carry on business. So this is in very rare cases. This power is only for beneficial liquidation. Suppose we have taken the real estate business example. If a partly finished real estate project is there and the liquidator has to decide to spend certain money on that project to complete it, so that after finishing the good amount of money can be recovered, can be realized, then as a going concern, the liquidator may uh, take the decision to carry on the business to that extent. And this carrying on the business is beneficially or must be beneficially for the liquidation loss and the maximization of the value of the realization. Then power litigation. The liquidator steps into the shoe of the management. You all know that after liquidation, power of the management already suspended during the CIRP. It gets suspended even in the liquidation process. So before going into this litigation, the liquidator must conduct a cost benefit analysis. Although, just a second, please. बस छोड़ दो बस बंद रहने देना. हाँ. So in certain cases where we can see that the cost of litigation is huge. Although if litigations are inevitable, we have to file the case, whatever the cost is there, but we have to cautious about hiring of the advocates or counsel based on the stake involved. Correct? So here we have to think what is the stake involved, how much the realizable value by filing the case and all. So we have to be very calculative to that extent. Then core duties of the liquidator, that is reporting and compliance. liquidator has to prepare the asset memorandum. Liquidator has to prepare the progress report each quarter, and it has to be filed to the adjudicating authority under the relevant regulations. Liquidator also has to keep the records of the proceedings, get the process to be audited, the receipt and payment account to be audited. So this is all there. This is very core duties of the liquidator. As far as asset memorandum is concerned, we can see that this documents provides the detailed explanation of the liquidation state, which is prescribed under section 36 of the IBC. It states that liquidators forms the liquidation state comprising of all assets of the CD, which are listed in subsection 3 of this section, which the liquidator holds as a fiduciary for the benefit of all stakeholders. The liquidation state basically is the assets of the corporate debtor. So what includes into the liquidation state are assets which owned by the corporate debtor. These assets may be tangible assets. These may be intangible assets, including the IPRs, securities, financial instruments, and contractual rights. So these are the assets which have certain monetary values. These are included in the liquidation state prepared by the liquidator. Then assets possessed or encumbered by the corporate debtor, proceeds from liquidation, assets relinquished by the secured creditors, and assets recovered through avoidance transactions. These are also the assets which need to be included in the liquidation state. As you know, there are assets which are exclusively mortgaged to particular secured financial creditors, and that secured financial creditors does not relinquish their security interest into the liquidation state. These assets are not part of the liquidation state. So there are certain assets which cannot be part of the liquidation state, or you can say they cannot be added into the liquidation assets. These are certain assets, the list itself given under section 36 subsection 4. So these assets are third party asset in possession of the debtor. So the assets which are there into the possession of the corporate debtor, but the ownership is not vested with the corporate debtor. These assets are basically held by the corporate debtor in trust and in bailment of the contracts, and owned by the third party are the assets not to be part of the liquidation state. Another assets are provident fund, pension fund, gratuity fund, which are funds and dues owned to the employees, which cannot be used for distribution, are the assets of the CD, need to be kept out of the liquidation state. Subsection 4 of section 36 specifically excludes these assets. Then there are security collateral subject to netting off and set off in trading. These are assets which are also not to be included. Personal assets of the shareholders or partners, or assets of the subsidiaries which are not part of the liquidation state, and other assets which may be notified or accrued by the law are not to be part of the liquidation state. We have already seen many ancillary judgments affirming these exclusions, clarifying that liquidation state does not include employee provident fund, employee pension or gratuity fund, and the liquidator has no authority over excluded assets. These assets cannot be part of the liquidation estate. So, until the assets are not part of the liquidation estate, this asset memorandum to be prepared strictly considering the provisions of section 36, and only those assets which are the part of the liquidation estate can be realized. So this is in brief about the liquidation estate. Then we have the stakeholder consultation committee. As we can see that this stakeholder consultation committee, the amendment of 16th September 2022 was brought in, and by this amendment the stakeholder consultation committee has been given supervisory or authoritative power, contrast to the pre-16th September 2022, where the stakeholder consultation committee has the advisory role. And if we see the IBC amendment bill, the stakeholder consultation committee is now the COC. So since it's a bill, we will not be discussing here. So we will discuss only the stakeholder consultation committee, which is at present in force. We have prepared something for the in relation to the stakeholder consultation committee under section 31A. It's not basically section, it's I think regulations. So I think it's a regulation 31, it's not section. There is composition. Representative of financial creditors, operational creditors, and employees, workmen, whosoever are the claimant, whosoever has filed their claim under liquidation process, and liquidator has admitted their claim. On that basis, a stakeholder consultation committee is constituted, and accordingly the composition of the committee will have the representation of the FCs, OCs, employee, workmen, and so on. Now, what is the purpose of the stakeholder consultation committee? The stakeholder consultation committee is there where liquidator can consult with the SCC. The SCC can guide the liquidator on liquidation related decisions. Certain powers has been prescribed under this process, liquidation process, and accordingly the SCC has the power even to replace or remove the liquidator. Voting right. What will be the voting right of the SCC under the liquidation process? Under the liquidation process, the voting right is not akin to the COC, because if you see the CRP provisions, the financial creditors has the only right to vote in the CRP process. But under the liquidation, every representative who are independent, who are not related to the CD or suspended management, they has the right to vote in proportion to their claim, amount of the claim. Then decision making, majority based on voting share reflecting members' stake. So every decision in the SCC is based on the majority decisions. Then we have the stakeholders group representation, we have already discussed, and the role of the liquidator. The role of the liquidator is to advise on the asset sale. Role in the liquidation, I'm sorry, of the SCC. This is to advise on the liquidation and the distribution strategies also. So this all has to be discussed with the liquidator and SCC in a meeting. And as I explained earlier, that the interest of all the stakeholders must be balanced by the liquidator. Although the section 53 is there, which prescribe the waterfall mechanism for distribution of the proceeds. Beyond that, the distribution cannot happen. So as section 53 is there, which take care of the distribution. So we have gone through the stakeholder consultation committee, and if we can see appointment, legal structure, and power. After SCC, we have already discussed this slide. One more thing, conflict. Multiple creditors classes often give conflicting advice, leading to practical management challenges addressed by the maintaining detailed record. So under the liquidation, this SCC having the certain. Yes, Mr. Bhupendra, do you want to discuss something? No. Okay. So we have gone through this. So we can discuss two case law here. One is RK Industries versus NCLT in Supreme Court versus NCLT. Supreme Court held that SCC advice is not binding. This is pre 2022, where when the amendment was not there. So earlier, since you know that the role of the SCC was advisory, so in that context, it was held that SCC advice is not binding on the liquidator. It is directory or advisory only. And another case was there for SJP Impacts versus Canada Bank, where it was clarified that priority in asset sale and necessity for transparent process and documentation by the liquidator. So these were the two cases important. We need to keep in mind. This is because the pre 2022. Now SCC new amendment, we can discuss in briefly that 2025 bill proposes to abolish SCC and transferring liquidation oversight to the COC constituted during the CRP. The final authority for critical liquidation decision now lies with the COC and not a separate advisory SCC. The asset sale under the new rule, asset sale decisions are made by the liquidator in consultation with the COC, not SCC. The requirement for justifying deviations from SCC advice is replaced by direct COC oversight. So SCC role, SCC basically will be the COC. That's it. This is under the new provisions, so we will not discuss here. We can discuss one case. This we will discuss in last. We will not discussing now. So let's come to the point-wise, bullet point-wise powers and duties of the liquidator. Upon appointment, the liquidator assumes all the power of the CT and has to manage and liquidate the corporate debtor. So since the appointment is there, let us in brief discuss the appointment of the liquidator also. You must be aware that there was one communication by the IBBI that the RP shall not be appointed as the liquidator. You can see that that was the communication only, even it was not circular or notifications, it was just a communication. IBBI has come out, and based on that communication, Honorable NCLT started working. But the practice before different benches of the NCLT was not same, or is not same, you can say, because it's at present also. Some of the NCLT benches apply that communication in their liquidation applications while passing the final order and not appointing the RP as the liquidator based on that communication. But some of the benches of the NCLT do not regard that communication as the circular notification, because it's not circular notification, it's only communication. So there is a confusion on this. So I think in the final bill which is coming, there is a provision that if the COC decide that the RP, so and so RP shall be liquidator, then NCLT will appoint that RP as a liquidator. So appointment is strictly in accordance with the provisions and IBBA regulations or communications or circular, whatever it is. The IP must be eligible, must having the valid AFA at the time of appointment. So these are the certain basic principles when and how the IP will be appointed as the liquidator. So this communication need to be dealt in as appointment of the IP as liquidator. So we have covered this. Then duties of the RP, we have already covered that it is the duty of the liquidator to verify the creditor's claim, take custody of the assets, evaluate and protect the assets, carry on the business for beneficial liquidation, and selling of the asset we will cover later part of this presentation. The liquidator can draw or and endorse negotiable instrument, initiate or defend legal proceedings, investigate financial affairs for undervalued transactions, and appoint professional for assistance. So this is also the duty of the liquidator to appoint the forensic auditor to inspect certain transactions, to find out whether the corporate debtor's business was running to defraud the creditors or not, what are the undervalued transactions, what are the preferential transactions, all these are things can be comes out once the liquidator appoint the professionals. Then liquidator has to consult. Yes, please. Yes, Ms. Jen, you want to ask something? Then under section 37, liquidator has extensive power to access information also for the purpose of verification of the claim, submission of the various reports to the adjudicating authority during the liquidation process, and liquidator is duty bound to maintain or keep the records of the CD up to 8 years post dissolution of the CD. Liquidator can disclaim onerous or unprofitable properties or contracts with proper authority or approval, with prior authority or approval of the by the AA. So in summary, we can say the liquidator's role under the IBC is comprehensive, involving asset management, business operations for liquidation, taking legal actions, engage with the stakeholders, and reporting with various authorities, IBBI, submission of the application before the NCLT, defending the matters before the various authorities to ensure an orderly and lawful liquidation process. So we have seen the power of the or duties of the liquidator here. Coming to the next slide. Liquidator's liability and protection. A liquidator can be held liable for misconduct or gross negligence. So, as an IP, we all are on the radar of the regulators. So, we have to be very, very careful while performing our duties. We also enjoy certain protections under the law, where when we are adhering the code and we are documenting all our decisions with reasoning, so and we can take the professional indemnity insurance also, we can be immune from the liability if we have the sufficient proof. Law protect us while performing our duties. Then the next part is core mandate, that is the assets and claims. We have gone through the asset memorandum already, so we will not discuss it. What is in, what is out, we have dealt in detail in the last slide, previous slide. Valuation we have already dealt in, so we will not go again to the valuation part. Avoidance transactions, briefly we can go here. So section 43 and section 45. These are the two sections which covers the preferential and undervalued transactions. Liquidator has to see, or the transaction auditor, if appointed by the liquidator, has to see whether any particular transactions has the character of preferential or undervalued transactions. For this purpose, under the Act, the period of 1 year has been prescribed if the transactions are entered between the unrelated parties and the CD. And in case the transactions are entered between the CD and the related party, then this look back period increased to 2 years. So for covering these transactions, the look back period is important. We can see in many cases that since last number of years, the CDs are not working as a going concern. There is no business and there are no transactions. So this look back period, considering this section, always are no transactions and these sections are not much useful. Then another section, we will come to this later, but another section is there, that is the section 66. So this is the section which is there. It has no limitations like the look back period. Under section 66, the look back period can be any number of periods. But the burden of proof is very high, very high on the liquidator. Liquidator has to prove that, see these are the transactions, but the limitation period like section 43 and 45, it is not there under section 66. And it only applies when the business of the CD was running with intent to defraud its creditors. So this is the section 66. Again, let us see the example in a very prominent case. The case was Anuj Jain, IRP of GP Infratech Limited versus Axis Bank Limited. This goes to the Supreme Court, and in the Supreme Court, in this matter, it was held that for a transaction to be preferential, it must be in relation to an antecedent debt. Mortgages created to secure new debt given simultaneously were not considered preferential, and it was clarified that the benefit must be for a creditor. Here, this judgment narrows the scope of what can be challenged as a preferential, requiring the liquidator to clearly establish the timeline of debt versus transaction. So if there is certain transaction which was there to secure another debt and the benefit was going to the creditor which was not related, so this preferential transaction was not uphold to be fraudulent, you can say like this. Then section 50 is there, which deals with the extortionate trade transactions. For again, this is with intention to defraud the creditor or to siphon the assets of the CD. So these are the fraudulent transactions which liquidator has to take care of. Claim verification we have already covered. Then practical challenges in claim verifications. This we have not covered. We can discuss briefly that when the CD goes into the liquidation, we are always missing with the records of the CD, missing with the payroll records, and verifying the claims of the workmen where the payrolls are not there is very challenging task for us. In case of appraisal creditors, we do not have the proper invoices, ledger, etc. and disputed invoices may also be there. So these are the practical challenges we used to face in every liquidation process. So based on the records submitted or documents given, we have to verify whether it is not tempered document, whether the documents some or other how matching with the available books of accounts. And in case of government claims, the extremely high statutory claims are there, and we have to rely on the documents submitted by those claimants. In absence of the records and documents submitted, we could get of the CD. Regarding the claim, we have one very prominent and one very famous judgment, Ghanshyam Mishra and Sons versus Edelweiss ARC, which was upheld by the Supreme Court, where the it highlight that the submission of the claim in time is crucial. How it is important that while this was a CRP decision, it says that, and it had established the clean slate theory, which says that once a resolution plan is approved, all the past claims, even those not filled, are extinguished. Based on this judgment, the all the claimant which could not file their claim, submit their claim in the CRP process, and even we can take this in the liquidation process if the dissolution order is passed and the claim could not be submitted, the uh, there are no chances of getting the claim admitted or getting the application for claim to be considered by the adjudicating authority. So this Ghanshyam Mishra and Sons versus Edelweiss is a very prominent judgment regarding the claim. For a undervalued transactions, we have mentioned here one example. Suppose in a situation where a company, knowing it was heading for financial trouble and sell a valuable piece of land which was having a value of 10 crores to of only 2 crores to a related party, then this is the undervalued sale, and the intention of this transaction was exclusively for the purpose of defraud the creditors, because if the assets of the CD having good value can be transferred, knowing that the company or the CD is going into the liquidation, then this is the undervalued transactions, and if it falls within the look back period, it can be challenged, it can be find out, and application can be filed before the NCLT for nullifying these transactions, and the benefits, any benefits from these transactions shall go to the creditors, genuine creditors. So this was the case. I have some difficulty here. Electricity issue is there, so I have to.
I have one query, if you allow me to ask right now.
Yes, yes, please.
Sir, actually, CD is having CD is a partner in one partnership firm
Okay.
and holding almost 99% stake in the partnership firm.
Who CD?
Yes.
A company in partnership form is shareholder.
Yes, company is holding 99% share in the profits of the firm, right? So the company of the business of the firm was also closed almost 8 years back, and practically it is not having any assets right now. Only thing is that the partner of the firm holding 1% shares in profits of the firm
Hmm.
overdrawn the capital by X amount.
Hmm.
That 1% shareholder partner is also director in the company, and avoidance application is filed. So,
Hmm.
what should as a liquidator should do in to take over the assets of the firm and discharge his duties?
For taking over the assets of this of
But actually, assets don't have any assets. Only thing is that capital is overdrawn.
sorry, only thing is
Capital is overdrawn by the other 1% partner.
capital is overdrawn.
Yes, yes.
So you have to file the application,
Or it is a patient side already.
uh, file the application against the partners of the firm, correct?
Right.
Against the partner of the firm, and so wait for the order. What else you can do? You can't do anything. Or you can file the as a creditor, you can file the application for insolvency.
Okay. Right.
If they are also the guarantor and all.
Okay. Okay.
Hmm. This can explode. This can be explored, na, considering all the facts are before you.
Okay.
Uh,
Right.
yeah. So I am saying some difficulty is here in my office today. So electricity is not here since last 10 to 15 minutes. So maybe some difficulty in continuing this session if electricity does not restore. So otherwise we are continuing this just to informing all the participants. Okay. Just hold on, please. Huh? Just a minute. We can take 5 minutes break, है ना, for now. Let me check. पता कर लो कब आएगी बिजली, है ना, बता लैपटॉप बंद ना हो जाएगी. Okay, let us continue till we have the electricity in my laptop. So the final act, let us discuss about the liquidation, है ना. Liquidating the assets means sale of the assets. So distribution we will cover later. This form we will also cover later. Bank net. Let us cover this bank net. So from 1st of April 2025, the IBBI has come out with circular that every IP who is acting as liquidator and cases in hand having the assets to be sold, they are mandatorily to be sold through BankNet platform. So this BankNet platform is a platform which is promoted by the banks basically, and the key points of this BankNet platform is that it is effective from 1st April 2025, and all the IPs who are handling liquidation must conduct auctions exclusively on this platform. First. Secondly, all unsold assets in ongoing liquidation cases were to be listed on BankNet by 31st March 2025. This was the mandate. So it is over, and every liquidator who are having the asset in hand for sale has registered himself into this platform. Another important amendment was made that due diligence of prospective bidders by the liquidator was removed under this amendment. In place, bidder must submit necessary documents, including declaration of eligibility under Section 29A of the IBC via this platform. And bidders was required to submit the EMD through this BankNet platform. So auction notice must clearly state that bidder eligibility and EMD conditions, including EMD, will be forfeited if the bidder is found ineligible later on. So this was the circular which was issued under Section 196 of the IBC. And the purpose of this platform was to ensure uniform, transparent and regulated asset sale through a single government recognized electronic platform for liquidators. For liquidations, this circular mandated all IPs who were handling the cases to switch over to this or to advertise their assets through this platform only. So, and all the unsold assets were to be auctioned through this platform. Thank God. At the same time, certain guidelines and FAQs were also issued in this regard. The bidders who are willing to take the assets in the liquidation process, the guidelines were prescribed for the registration of the bidders through this platform, and these were the guidelines like bidder has to get himself registered, he has to participate only if he is not eligible, he is eligible to under section under the IBC is not party eligibility under section 29 must, and the forfeiting of the EMD provision was also there if the bidder is disqualified. So these were the issues, these were the provisions which were there in the IBC recently, because earlier we used to different platforms for auction assets of the city, but now there is only one dedicated platform where we have to list our assets for sale under the liquidation process. Now let us see the summary and mode of the sale during liquidation. We have briefly list out here certain things, how the assets is sold out. So under the liquidation, if we see regulation 32E to F of the liquidation process, it lists out how the asset will be sold out by the liquidator. Yes, Bhupender ji, do you want to share something?
No, sir.
Okay, okay, thank you. So, under these regulations, the first attempt by the liquidator after the liquidation is liquidator must sell the CD or its business as a going concern to maximize value. So the first attempt would be to sell the CD as a going concern as a whole. Then, if creditors identify, suppose, certain assets as a going concern, liquidators sells accordingly as group with SCC consultation. So, in the first meeting of the SCC, the liquidator will consult what are the assets which can be sold out in a group, or what are the assets which can be sold out in piecemeal or separately. So, asset grouping for going concern also. So, there are different regulations prescribed. Regulation 39, sub-regulation 2, 39C, sub-regulation 2 of the liquidation process regulation 32. So, here the grouping of the assets can be sold. Then, if the sale of the assets or sale of the CD as a going concern fail, only then these CD or the assets of the CD can be sold out on a standalone basis, slump sale basis, or set of the assets, or in parcels, in parts. Regulation 32A to D. These are the governing regulations which deals how, in what circumstances it can be sold out. Then we have another section 52 of the IBC, which lays down that the assets with security interest cannot be sold out unless security is relinquished to the liquidation state. We already told this during our presentation that if the assets are not, if the mortgage assets, the security interest is not relinquished into the liquidation state by the financial creditors or by the secured creditors, then these assets cannot be form part of the liquidation state. So this deals with the security interest assets. Then we have orderly mode of sale. So schedule 1 of the regulations, of the liquidation regulations, prescribe that how the assets under auction would be sold out. Under the auction, the assets would be sold out. We have uh, the entire regulations. Let me show you. Allow me by a moment to share the relevant slide. So this is the going concern sale. concept of going concern, we will not go into this. Meaning of going concern, we will also not going into this. So this is eligibility, it's over. Distribution, no, this is not this relevant. नहीं है, कहाँ चला गया? हाँ देख भेजा है, हाँ वो दिख ही नहीं रहा, वो इम्पोर्टेंट ना वो। अच्छा ये है 33, ठीक है, वही निकाल रहे ना। एक मिनट, दिख ही नहीं रहा, कहाँ चला गया शरीर में, देख रहा हूँ। भेज दिया, ओके 33 उस पर नहीं लगाया था क्या? 33 पेज 33। Yeah. So this is the schedule. Sorry, I was searching the schedule. So I've taken from the regulation itself. So auction, this is the general guidelines prescribed under regulation for the sale of these assets under auction. So where an asset to be sold out through auction, liquidator will devise a strategy for sale of the assets. For this, marketing strategies will also be devised by the liquidator. And for this, liquidator can release the advertisement. Liquidator can prepare the information sheet for the assets, notice of the sale, and liaison with the agents for sale of the assets. This is the general guidelines for sale of the assets through auction. For this purpose, liquidators shall prepare the entire terms or the, you can say, the documents of sale, which will include the reserve price, EMD, as well as the pre-bid qualifications for the sale of the assets under liquidation. In this process, reserve price is fixed and the reserve price shall be, there is no option, but the reserve price shall be the value of the assets arrived under regulation 35, means the average value or the liquidation value, realizable value of the asset shall be the reserve price. So this is mandatory requirement. Then regulation, then 4A, the clause of the schedule says, where an auction fails, the liquidator may reduce the reserve price by up to 25% of such value to conduct subsequent auctions.
Sir, reserve price, I have one query regarding reserve price. So it is value as per assets arrived in accordance with regulation 35. So there are two values that are calculated. One is share market value and other is liquidation value. So liquidation value will be the reserve price.
Correct.
I'm just asking. Right.
Correct. So that value will be the reserve price. And if this auction is failed, correct? In the subsequent auction, in the next auction, the maximum price which can be reduced is 10%. But it can go up to 25%. This is only once. Only once it can be reduced up to 25%. And later on, it is mandatory to be done not more than 10%. Am I clear?
Yes, sir. Yes, sir.
Thank you. Then, sir, we have another provision in this regard, where the auction fails to reduce price so and so. In subsequent auction, it may further reduce by not less than 10%. I've told you this. Then liquidator shall make a public announcement of an auction in a specified manner. So this is the procedure. The manners are specified how the public announcement will be made, provided that the liquidator may apply to AA to dispense with the requirement of regulation 12(13)A, keeping in view the value of an asset intended to be sold by auction. So AA is always empowered to relax based on the discussions or decisions with the SCC and the applications of the liquidator, depending on the nature of the assets and all. The liquidator shall provide all assistance necessary for conduct of the due diligence by interested buyer. It is the duty of the liquidator to cooperate and to provide all the assistance which are necessary to the buyer, to the intended buyer who is willing to bid in this process. Then, since this BankNet platform is already there, so the auction will be conducted through this platform only. In the bidding process, the highest bidder or the highest bid price shall always be visible. And if the liquidator consider that visibility of the highest price may not be proper, and the requirement for this visibility may be dispensed with, this may be done with the approval of the AA by filing the appropriate application before the AA. But the purpose of this must be to maximize the realizable value of the particular assets or the CD. And there is one more point, number 11. If you can see, if required, the liquidator may conduct multiple rounds of auctions to maximize the realization from the sale of assets and to promote the best interest of the creditors. In that case, liquidator may not declare even the highest bidder as the winner of the process. But the purpose of this must be to maximize the value. Then point number 12, it says that on closure of the auction, the entire payment must come within 90 days of the closure. If it delays, then 12% interest would be there after thereafter. A period of 30 days is there. So all the payment must come within 90 days with interest within 90 days, without interest up to 30 days. On payment of the full sale consideration. So this is the private sale. The private sale option may also be opted or exercised by the liquidator with the consultation of the SCC, but subject to approval of the AA. So these all the regulations which are there. Now come to the liquidator fee. Timeline we have gone through. So this fee part is also important. The fee of the liquidator, the relevant section is section 34, subsection 8 of the IBC, which mandates that a liquidator charge the fee in proportion to the value of liquidation staked asset and the fee paid from the liquidation proceed under section 53, whatever asset realize. The liquidation cost include, let us understand what is the liquidation cost. The liquidation cost include all costs incurred by the liquidator during liquidation period and are broadly defined under section 516 of the IBC and relevant IBBA regulations. Here we can see that for determination following three categories under liquidation process, regulation 4, the fee is there. One may be the fee fixed by the COC in consultation with the RP, covering period such as compromise or arrangement under section 230 of the Companies Act, sale period and liquidation balance period. So all this have to be there. If you remember regulation 39D, when we file the application for approval of the plan or the resolution where the COC resolve for liquidation, we used to place this resolution under section 39D to request the COC to pass necessary resolution in case the order of liquidation happens by the AA. So the fee under that regulation may be fixed of the proposed liquidator. One, either the fixed fee for the period under the compromise and liquidation, then for the balance period where the sale or liquidation process continued, and third, after sale for the balance period. So this is the first mode of the fixation of the fees. This is prescribed under regulation 4. Second, if COC does not fix, the stakeholder does not fix, the SCC will fix the fee of the liquidator in its first meeting. If neither COC nor SCC fix fees, the liquidator will get the fees as prescribed under regulation 4, where certain percentage is given. Certain percentage are given. So we can visit this regulation 4 here under the regulation. So these are the amended regulations. Here you can see the percentage of fee of the liquidator. Basically, there are two scenario, or you can say the two event when the liquidator get the fee. First on realization and secondly on distribution. The slab of percentage fees based on the period under which the liquidator has realized the amount or distributed the amount and distribution the amount that is there. So the we can see here then on first 1 crore of realized amount, if that realization happens within first 6 months, then the fee will be 5% if no fee is fixed by the SCC. Then accordingly the slab is there. Another fee is on the distribution. Once the liquidation of the asset is done, payment received, that is the realization, and that payment which is received by the liquidator is distributed as per section 53, that is the distribution. So the other part for distribution will be as per the second heading, this amount distribution, and first is amount realization. So accordingly this is distributed. If you see the clarification, there were certain dispute, or you can say certain case law of the Bombay High Court in Amit Gupta versus IBBI, where the IBBI has come out with the circular that to exclude the period, this 6 month, the approval of the NCLT is necessary. So this part of the circular was struck down by the Honorable Bombay High Court in Amit Gupta matter. And thereafter the IBBI withdraw that part of the circular to end the litigation or to end the dispute on that very circular. So this is the regulation 4, which deals with the fee of the liquidator. After sale of the assets and fee of the liquidator, let us see how the sale proceed is distributed. We have last slide in that regard, distribution. So section 53 is
I
there.
have one query regarding remuneration, if you allow me to ask. Like if SEC decides to fix the remuneration, so generally, practically, how it fix? It fixed as per table or some other method, monthly or.
See, if you see the regulation, right? Regulation 39D of the CIRP regulation, which mandates that while you are filing the resolution plan or the COC is resolving for the liquidation of the CD, RP has to place before the COC the fee of the liquidator which is fixed. Correct? Estimate of the fees, whatever is it.
Yes, yes, yes.
So if it is decided at that point of time, the fee will come to the, accordingly. Correct? If the COC has not decided under regulation 39D at the time of filing of the application for liquidation or filing of the resolution plan, but later the company goes into the liquidation, then in the very first meeting of the SCC, the SCC will decide. Correct?
Yeah, right.
SCC may decide according to regulation 4 or may decide the fixed fee, whatever SCC may find it and acceptable to the liquidator. If none of them it decide,
Then table comes.
then this regulation 4 table will apply.
Okay.
Is it fine, sir?
Right, sir.
Yeah. Now, sir, coming to this distribution part. after the realization and deduction of the liquidation and CRP cost, whatever proceed remain, this is distributed under section 53 of the IBC. So how it is distributed? First, CIRP and liquidation cost will be deducted from the sale proceed, correct? Then the workman dues for 24 months before the liquidation start, that amount will be given to the workman. And the debt of the secured creditors who relinquish their security. So these two creditors will be distributed at par. Workmen with 24 months of dues and the secured creditors who have relinquished their security interest into the liquidation state. If anything remains, then wages and dues of other employees up to the 12 months of the LCD. Then these unsecured financial creditors due will be distributed. Then it comes with the central government or state government dues. Then other. So this is the waterfall mechanism, but in 99.99% cases, the entire sale proceed exhaust in above 1 and 2, and in some cases in 3, and below that nothing remains for the other creditors. So this is something which is very not very good for any of the process because of the size of the assets which really remains under the liquidation and the CRP. If really the assets are there, the CD goes in CD dissolved during the CRP, the liquidation stage may not come. But in the cases where the assets are not there or insufficient assets are there, then it usually goes into the liquidation. The scenario is like this. Now, let us see, it is already 5. So we have prepared some questions for the test of our knowledge. So, and to interact with each other. Yes, sir. So let us see. We have a very good judgment in the rainbow paper. So we have prepared these questions for this in the Supreme Court judgment in rainbow paper. The primary impact which primarily impacted the priority of the payment, which shareholders in the waterfall mechanism. If one has gone through this judgment, then what was the stakeholder in this matter?
Unsecured financial creditors.
Unsecured financial creditor. No, sir.
Yes.
It was the government authority.
Government, basically, they have given priority to government authorities.
Government
If they
authority. Yeah. Yes.
have
VAT.
if
VAT claim, sir.
statutory dues, basically.
It was the claim of the VAT department. Correct. Statutory dues. Another, sir. This has to be very interactive. Another is just a second, sir. Okay. As per the principle laid down in Sunil Kumar Jain versus Sudarshan Bhatt, which of the following is treated as top priority CRP cost? The option are all employees' salaries for the last 12 months. Second, sorry, disturbances here. Second, unpaid wages of only those employees who worked during the CRP period. Third, gratuity and pension fund dues. And D number, the total debt owed to OC. So what is the correct answer, sir, in this Sunil Kumar Jain versus Sudarshan Bhatt? If any idea? So in this matter, let me brief you that the claim of the worker was given the topmost priority. So the answer would be B number, basis of employees who work during the CRP. So this is the CRP cost, basically. This was held in this. Now, after the case law, these are the general provisions. The stakeholders consultation committee is formed under which legal provision? Section 33, 53, 31A and 21. SCC सर किस सेक्शन में बनती है? This is sir. What is the correct answer? Point number
C, sir. C.
C. Excellent, sir. Thank you. We are playing like a child, correct? Sometimes it must happen. Then, sir, transaction where a company sells an asset for a price significantly less than its fair value. It is known as fraudulent or preferential or undervalued. Undervalued. Very good, sir. Correct. Then, sir, what is the look back period for an undervalued transactions with a non-related party? Now, this
2
is the
years.
non-related party. So, 6 months, 1 year, 2 year, or 3 years, whatever it is.
2 years. 2 years.
Sir, non-related party, it is 1 year.
Non-related party.
For related party, it is 2 years.
Yes, yes.
Yeah. Under section 52, a secured creditor who chooses to realize their security interest must contribute a portion of the proceed to whom? Liquidator fees, unsecured financial creditors, government dues, workman dues. I'm reading it again. Please consider it. Under section 52, 52 applies where the secured creditors has not relinquished his security interest or its security interest to the liquidation state. That secured creditors who realizes their security interest himself, means outside the IBC, he must contribute a portion of the proceed to whom? Liquidator fees or unsecured financial
Liquidator
creditors
fees.
or government dues or workman dues, sir. What is the correct answer? Sir, the correct answer is D, because if he is going outside the IBC, the question of liquidator fees will not arise. Correct? It is the workman dues which is associated with that asset. He has to bear that. Item numbers, question number 7. Not much question, only certain questions are there. Which of the following is explicitly excluded from the liquidation state? यहाँ पे exclusion की बात कर रहे हैं हम लोग. Intangible assets like brand value या assets located in foreign country or provident
fund and gratuity funds.
I think it's right. Correct. Provident fund will be outside the liquidation state. Question number 8. What is the minimum voting share required in the COC to approve a decision to liquidate the company and during sale?
66%.
66. Correct, sir. 9. Liquidator running a company's factory for 1 month to complete a profitable order before selling it is an example of fraudulent trading, undervalue transactions, carrying on business for beneficial liquidation, or exceeding their power. I am reading again. A liquidator running a company's factory for 1 month to complete profitable order before selling it is an example of, is it a fraudulent trading, or it's a NW transactions, or it's a carrying on business by the liquidator for beneficial liquidation, or exceeding their power? What is the answer, sir? Answer is C, carrying on business for beneficial liquidation. Now we have gone through some real estate example, if you remember, in today's presentation. Then question number 10, moratorium under section 33(5) during liquidation prevents liquidator from selling assets, filing new lawsuits against the company, resignation of employees, the SCC from meeting. What it restrict? What it prevents? Section 33(5). Sir, it prevents the filing of new lawsuits against the company. Then in section 53, waterfall, who is on the highest priority payment? Unsecured creditor, government dues, both are paid at the same level, or unsecured financial creditors rank higher than government dues? Higher priority out of these four. Unsecured financial creditors rank higher than government dues. Then Swiss challenge method is a process primarily used for verifying claim, or adopting or appointing a liquidator, or conducting a transparent asset sale, or forming this SCC. So this Swiss challenge method basically for conducting a transparent sale. Who is responsible for appointing the valuer during the liquidation process? Is it NCLT or SCC or liquidator or IBBI? The liquidator appointed by the liquidator. There are only 20 questions, 19 questions. So 14 is there. What is the final legal action that causes a company to cease to exist? The sale of all assets, or the final distribution of proceeds, or the filing of the final report, or the dissolution order from the NCLT. This will be the D number, the dissolution order from the NCLT. The Gujarat Urja Vikas Nigam case established that the moratorium can be used to prevent termination of critical contracts, freeze the personal assets of the promoters, stop all payments to operational creditors, extend the liquidation timeline indefinitely. Sir, in this case, this moratorium was used to prevent the termination of the critical contracts. What is the timeline for liquidation? Liquidator to submit the preliminary report, 75 days. And which of these reports is not prepared by the liquidator? Asset memorandum, progress report, valuation report, and final report. Valuation report is not prepared by the liquidator. So, and the last is, if secured creditors enforcing their security realizes more money than their debt, what they do with the surplus? Keep surplus amount, distributed to the other creditors, return to the liquidator, or paid to the government? The answer is C, return to the liquidator. So with this, this presentation is over. Anjali ji, are you there?
Sir, one last question. I'm sorry, I'm bothering you again.
Sir, please ask. You are keeping this session very interactive. Please.
Sir, if asset is sold to CD is sold to the sale is done as going concern. So in that case, how distribution of assets is done?
Sir, sale as a going concern, na?
Yes, sir.
Distribution shall be as per waterfall mechanism, section 53.
As per waterfall.
Ah.
In that case also.
In every, that is the mother section, na, for distribution.
Yes, 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 yes.
Any money, any amount which flow to the liquidator, it has
So, sir, my query is basically if particular asset is also secured asset. So and FC has not relinquished his share.
correct.
Liquidator is selling basically. That asset is also sold by a liquidator.
If the assets, if the right,
Not relinquished basically.
it is not relinquished.
Yes, sir.
If it is not relinquished, liquidator cannot sell
That will be sold by FC only, no?
by FC only.
So in other cases, he has relinquished his share.
Ha.
So in that case, how distribution will happen?
Sir, if that is the only
Because,
asset.
but my query is basically how we will basically divide the proceeds with the different assets. Like if we have 3 assets and sale is done for X amount, so how we will distribute in amongst all assets?
Okay.
First of all, we have to do that, no?
Let me clarify, sir. First scenario, there is only asset in the city, and
Yes.
there are 2 financial creditors. Correct?
Yeah, right.
One financial creditor having the exclusive charge on the asset.
Right.
He knows that if the interest in that asset is relinquished, then the asset will come into the liquidation state, and the distribution under section 53 will be as per section distribution will be as per section 53. In that
Right.
case, both the FC will get the distribution as per their percentage of claim. Correct?
Right. Right.
So, considering that scenario, the FC who is having the first charge over the asset choose not to relinquish his security interest into the liquidation state.
Right. Absolutely right.
He
At least as per current provisions, situation may change
section
after that amendment bill is passed. No?
section
In that
52.
case, yes.
Section 52. Section 52, he goes out of the liquidation process. He takes his asset outside and he sold it under the SARFAESI. Correct?
Right.
Whatever proceed he realizes, if it satisfies his claim, whatever dues are there with the company, then he will keep all the assets with him, all the proceed with himself if it is short of the claim. If it is exceeding the claim, the excess amount will go to the liquidator. Second scenario. Third scenario, your question is how the liquidation expenses will be beat out. Is it your question?
Right, sir. Yes.
So in that case, whatever CRP cost is there, correct? Whatever CRP cost is there, and the point he had opted for getting out of the liquidation process by not relinquish the assets, he has to bear the entire cost if there is only asset in the CD. Correct? If there are other assets also, then the liquidation proceed, whatever will be there, the liquidation cost will be made out from those of the assets which are part of the liquidation state. But the FC who has taken out of this, who is not relinquished the estate asset and taken out from the IBC process, then you cannot ask for him to share something in the liquidation process. This is to my brief understanding, sir.
Right.
Yeah. Anjali ji, are you there? I think Anjali ji is not there. No issue. So we can, any other thing, Bhupender ji, we can discuss?
No, sir. Thank you.
Okay. So,
Can we conclude, sir?
yes, Anjali ji, we have finished our part as of now.
Okay. Thank you very much, sir, for your valuable contribution and sharing
And
your learnings about the topic.
thank you.
Sir, you requested to please share the PPT also.
Yes, yes, I will share, and I must thank all the participants who was here staying throughout the session to present and keep the interaction with us, make the session interactive. Thank you all. Thank you, Bhupender ji, especially for asking for making this
Thank you
live
very much.
session. Thank you.